Hello, hi, so everybody. Hi, this is Ken O from Canton Chambers Lawyers. This is a second part of employment law in New Zealand. And then this is 31st of October 2018. And then I think we have start early this year, but already for end of October, time goes so fast. Some people think, okay, time goes so slow, and then but some people says this time goes so fast, and then depends on your age, and then they feel like time goes so fast or like a slow. There is a joke that if you are a teenager, then your time goes like some 10 kilometer per hour, and then 20 and then 20 kilometer per hour. Then if you are 60s, 70s, then time goes like 60 or 70 kilometers per hour. Means that when you get old, then time goes so or like fast. And then how old are you? Then you can how you feel like time goes fast. Okay. So we will like discuss today in second part of employment law here in New Zealand, and then we can I can briefly summary for last part, and we do for like a brief summary of the employment law here in New Zealand, employment terms and condition. Uh, so in employment law, employment contract is actually, and this is a purely a contract between employer and employee. But this employ and the contract shall be within a boundary of the employment law here in New Zealand, right? And then if the terms and condition negotiated between employer and employee is within a boundary of employment law, then still this is valid, and then can be enforceable each other. But in New Zealand, like all the employment case, and then why is this so like shaking there? Okay, just a second. Yeah. Sorry, there's camera is maybe shaking there. Okay, stay there, don't move. So I just a briefly summary for employment countries for fixed term, and then permanent term, and then casual term. Many kinds of employment contract there, and depends on New Zealand for situation. You will make some full time or part time, casual, or like it depends on the systems. Okay, so. Maybe we can today is more like some actual, like when you work here in New Zealand, and then many of the employees and then employer got some trouble, and then but this is more focused on for the employers and employees position, because new migrant comes to New Zealand and work for the employer, and then employer something like against you, and then so you do not understand of employment law here in New Zealand, and then might some victims. So this is not good for New Zealand reputation, because New Zealand is a really highly humanitarian ground country, and then we respect of all the people here in New Zealand is regarded as very valuable people and valuable employees here. So as I told you in the last weeks, and then in New Zealand we got all the equal like opportunity chance for, even though like employees are overseas people or New Zealand citizen or New Zealand residence visa holder shall be treated as equally, and then that means that even though like foreigners, if they work here in New Zealand, they will be treated as the same equal right with New Zealand citizen or New Zealand residence visa holder. So that means doesn't matter your nationality, doesn't matter for your visa status. As long as you work here in New Zealand, you will be treated as the same and equal with a New Zealand local citizen or residence visa holder. Maybe some country has some discrimination of the foreigners, but in New Zealand, we do not do that. Okay, so today, and then we can see for like some important terms and condition of your employment, and then most important terms, and you have to remember is one of that is for 90 days trial. So since for New Zealand National Party was a government, and then they introduced for 90 days trial period. What this means? Means that once you gotta start of work for the employer, and then within 90 days of your first working day, and then employer may dismiss or may terminate of your employment within a 1 week notice. In such a case, they will usually give some the reason, but in that case, for employee cannot claim against any compensation. This is the main thing. That means for if the employer do not satisfy of employees for work efficiency, work performance, and then they can easily for like a terminate of their new employees for employment the contract. And then the main purpose of this clause is that for help for each other, for employer and employee. And then if this is a too much difficult of termination of the employment contract, and then employer is a very cautious, very reluctant to give any job offer to new people or like unidentified or known people. So that means that this clause was for the actually for the new migrant, new people here in New Zealand. That means employer can test or trial to the new people who is not a New Zealand experienced people, who doesn't have any New Zealand qualification people. So employer can try, and then for 90 days, and then employee can prove that he or she is a really good skilled people, and then can prove that this is a really good employees, or can contribute a lot for the company. Then employer will satisfy and just keep employment that person. But if in that case, the employer may got some more relaxed to try of new migrant, like new people, like unidentified people. So in New Zealand, usually for the good company or like big company, they use for recruiting agent, and then the recruiting agent for very severe like assessment or like some interview system. Through that past, the people can get only for the visa or get some got some employment here in New Zealand. Then employer rely on for recruiting agent for screening and then recommendation. They employ only that employees for that company. That means in such a system for new migrant, new people who doesn't have any experience here in New Zealand, get some not high chances to like passed by assessment and interview by the professional recruiting agent. Recruiting agent doesn't want to make any loose, and then doesn't want to make any mistake for providing new people to their reliable employer. So that means a recruiting agent are more like a cautious for screening of the new people. But sometimes there's some always advantage and disadvantage by abusing of this 90 days trial, and some bad employer use for this one for fire or terminate of new people without any giving a proper the reason. Okay, this is I can terminate of your the employment. Okay, I'll give you 1 week notice, then so you are the fired, or some your employment will be some terminate, and then this is a disadvantage of this clause. So far, and then labor department, labor government, they try to remove of this for 90 days trial, because many employees feel like some very uncomfortable, and then very some scared of for 90 days, some, oh my god, and so can I lose my job or not?
Within 90
Mm.
days.
So the union pushed that government. Okay, so this is no good for clause for the employees, and then so then labor government tried to remove this clause under this government. So maybe we can see that, and then what happened in the future. But in anyway, for 90 days trial is for the original purpose is for giving more chance to new people. But if the 90 days trial is removed, and then employer may more cautious, and then gets more a closed mind to give any chance to the new migrant. But yeah, so this is a reality now. And then, okay, I will give some explanation. Very common thing for most of issue in the employment the law, a dismissal, employer said, okay, so your employment is terminated, and then if this is a fair and reasonable a dismiss, and then it is okay for acceptable for the employer and employee. But sometimes employer do not satisfy employees work efficiency, work performance, and then suddenly for fire them, and then in the case lots of headache and lots of trouble between employer and employees. Actually, for employment law is for originally the purpose is for fair to employer side, employee side. There's a reason why the employment law has a very the fairness in there. But practically, and there's most of obligation or burden or responsibility belongs to the employer side. And then if the employer is a really big company, and then there's for human resource department, they got all the requirement for some paperwork for meet all the requirement under the employment law. But most of New Zealand business is a small business, means for employees number is between 5 to 20 employees, and that means for most of employees has to do for multitask. Not only one thing, then he has to do for one thing, and then in addition to for major role to for other additional work. Then this is a small business. That means for employer is always a short of hands, and then that is the reason why the employer cannot meet all the paperwork requirement. And then usually while they're working, their relationships are good, and then they agreed, and then orally agreed, and no complaint, no problem there. However, if the employer some terminate of the employment, then the employee doesn't like that, and I'm going to complain against for employer, and then bring it to the labor employment relationship authority. This is a government body, and then they are going to start for the legal challenge against employer, and then employer cannot prove the evidence, and then such a date like we already agreed. Then employer, okay, oh no, so I didn't for agreed, and then I cannot remember. Then the employer, oh my God, and so I don't have any evidence, only for oral agreement on that day. And then employment court, they said, okay, you cannot prove that evidence. There's no paperwork, no paper evidence. There's you are breach of the employment law, and then judge or like a referee of the employment relationship authority or employment court, and then judgment against employer. Then employer gets was so sad and so angry. Oh my God, this country is so all for the employees benefit for the old employment law. And then this is a theoretical and there's a practical issue there. So that means for employees side, and then they usually later on change their mind, or they make a claim against for then we can usually say, okay, more than 90% of winner is for employees in New Zealand. Employee will win against employer. But practically small bit is all the employers got a whole obligation, and then doesn't have any time to paperwork, and then there's a reason why. So in the case for the employer side, and then we do recommend for make us some evidence. If they are really busy, make us some note on there. I mean, such a date and such a place, and then for who was there, and there's such a discuss, and then such agreement like this, and then can be possibly accepted as evidence of that the meeting or agreement. So the employee side, and okay, so okay, that's fine. I will use my more benefit later on if there's any problem there, right?
Question, Mr. Kent, concerning about employees, because Mr. Dicky, our viewers, Dicky A. Friday,
Yeah.
maybe the question is, there's any kind of requirements for the age of applying in migrating here in New Zealand?
Okay. Yeah. So this is a good question. I can say for a visa types, and then okay. When we do for new migrant, always there's two issues there. One is for employment issue. One is for visa issue, right? The employment issue, then as I told you earlier, there is not any discrimination, the clause or discrimination things in employment matter. So no age limit, no age discrimination, no gender discrimination for, and then or what is that, for age or any gender, for or any language, or that does you shouldn't put your employment advertisement there, right? So in the employment matter, no limitations. Everybody shall be treated as the same, as equally and fairly. However, immigration side, and then there's two things for a purely a temporary visa, means for purely work visa side, and then there is not any age limit, and then there is not any gender limit, there is not anything limitations. As I told you earlier, shall be all treated the same as New Zealand citizen or residence visa holder. So as long as your employer and the employee are happy to work together, and then you can apply for work visa, right? So, however, when you apply for residence visa based on for your employment now, such as for essential work visa or open work visa, but there is a definitely for age limit to your the residence visa application. Means for I can say that if you get old, then your validity of using being used in New Zealand as an employee is very limited. So your value is like lower, right? And then you got some more less point or like less value. So you are younger, then you are you will work for the New Zealand community, New Zealand economy for longer, then you will get more value there. So in a residence visa side, you got some age limitations there, and there's up to like 55 years old, and then you can apply for residence visa based on your employment. But if you're over 55 and 56, and then you are disqualified, right? So that means the age limitation for visa side, residence visa side, there is 56 years old. For you cannot apply for residence visa. However, purely for work visa and then essential work visa, no age limit, and then you can work as long as you can work, and then you can get it. Okay.
Sir, so reality question, sir. What if speaking of essential skill visa, if for example, if a chef and work in a new employer, and so happen the employer during the 1 week of trial that this chef is not highly, not meet the requirements of the employer, does it have employer a right to to terminate the contract, or he or she needs to keep the chef on to work with him?
Okay, so as I explained to you just before, and then most of employment contract in New Zealand has a 90 days trial. But if the employment contract doesn't have any 90 days trial clause, and then so you cannot easily terminate of the employment, right? So if the 90 days trial is not there, then you have to be a fair procedure to terminate. Means for usually in New Zealand, you have to give for at least for a second twice warning to the employees. So for example, any efficiencies are lower, or if you do not follow the policy of the company, and then usually for manager and then employee, and then it's better to set any third party. Then at least three parties sit together, have a meeting, and then what is your issue then, and then discuss, and then for later on give a report to the employee and then employer. That means this can be used as for review of the work performance, or any warning the letter to the employees. Then shall be at least 2 times of that process of the review or warning. In a termination side, employer has to give at least 2 times of written warning letter to the employee. And then third time, don't give any. Then third time that happens again, and then give any termination. You can do that. Mm-hmm. However, if there's a 90 days trial, as I told you before, within 90 days of the employment start, and then if not happy, and then you can terminate that employment with 1 week's notice, right?
And to what happened to the visa of the employee if he or she will be terminated, sir?
All right. Okay. As I told you, in there for foreigners side and the employment matter issue, for immigration visa matter issue there, right? If your employment is terminate, and then for this visa will be terminate automatically. Depends on your visa status. If you got some open work visa, then regardless of the visa status, you can work for any employer, any jobs, any hours you can work there. However, if your visa status is for essential work visa, means that for your employment visa is very clear. Your working area in maybe Auckland area, and you work for the employer, specific employer, if your position title is a specific title there, usually for your work visa status for three things, like some for area, company, like some your title position there. But if you lose that your job and then you have to find another job, another employer, and then have to employment contract basis for then you have some two ways for apply for variation of the condition. We call this VOC, and then or like some you have to apply for a new visa application. Got some new visa approved, then so you work for the new employer, right? Yeah.
So may you maybe request to kindly greet our viewers.
Okay. Nika, so hello, and then Helen, hi, how are you? And then Maxil, how are you? And then Gagan, and then okay, so okay. So also like Ranil, and it's very nice to see you here, and then thank you for that. Maybe you can share of our the life in the future with your friends. Yeah.
What do you what do you expect next week? Because mostly our viewers asking like what they will expect from us next week on our topic. Are we going to discuss about the more immigrations or more of the reality kind of what's going on with New Zealand?
Okay.
What can you say about this?
Yeah. Before that, I want to make one thing. Okay. Most of employment contract has like misconduct dismissal. That means for if you do any misconduct means for a bad thing against for business or employer, then employer can terminate of your employment straight. For example, if you steal money from like employers till or any like many like on misconduct the product, I mean misconduct for behavior or the samples in your employment contract. In such a case, like if you commit of misconduct and an employer can terminate of your employment straight then terminate. So then is a no pre warning is required. So please note that. And then so if you do any misconduct and then your employment will be terminated by automatically, not automatically, immediately by the employer, right? So, sorry, what was the question? Like we can.
So what our viewers, what they can expect from us next week, sir?
So, any topics if you want to discuss with Canton Chambers Lawyers Facebook Live, and then please send some request, and we can consider. Then we can make some topic there. And also, like please do like our main page. And as follow our main page, then you will get some more information from us. And also, okay, if you got any information, if you need any information or any advice from us, and then please send your questions to us, like a visa apply, right? Visa apply, and then visa apply at cantonlaw.co.nz. So you can send it to us, okay, and then we will like reply to you. Your questions and then advice to you. Okay, so please don't forget for like our main page and follow our main page. Okay, thank you. Bye bye.